Hi, everybody. Thank you so much for joining us today. I am Michelle from Consolidated Planning Group. We were just talking about our dogs, our pets, and how much we love them. But we are here today to talk about guardianship, and we have a fantastic presentation from attorney Melissa Donovan. She is going to help us understand guardianship, why it's so important, what some of the pros and cons are about full guardianship and alternatives. And we did receive some questions ahead of time, so we're going to try to get to as many of those questions as we can. Before we get started, I want to kind of go over a little bit of housekeeping stuff. First of all, we are in webinar mode, so I can't see you or hear you, but I know that you're out there. I see the participant count, and that's what the chat box is for. Please put any questions or comments in the chat box, and we're going to get to as many of your questions as we possibly can today. Now, we do record all of our webinars and we put them on our YouTube channel, and I already put the link in the chat box for that YouTube channel. After today's webinar ends, you will receive an email with the link to the recording and also the slides that we go over today. So you're going to be able to watch this whole thing over again as many times and as often or whatever time you want. But I do appreciate those of you who join us live during our lunchtime talks. If you need anything, of course, my email and cell phone number are in the chat box, and you can reach out to me directly. Consolidated Planning Group, whether this is the first time you're with us or the 31st time, we're really glad you're here. We are a special needs planning firm located just outside of Houston, but we work all across Texas and all across the United States. Now, today's webinar is going to be a little bit more focused on Texas because guardianship laws vary from state to state, and we are in Texas. We have an attorney from Texas. So most of the stuff we're going to talk about today will pretty much be related to Texas law. However, in general, we can help anyone across the entire United States. We have over 30 years of experience with insurance and securities, investments, things like that. We're members of the Special Needs Planning Academy. We are national Social Security advisors, and I am a chartered special needs consultant. Families come to us for things like protection plans, lifetime care planning, transition planning. There's a lot that goes on when your child graduates from high school, when they turn 18, when they're ready to move out of parents' home. A lot of big transitions that need to be planned for. We help with ABLE accounts and understanding what buckets your money needs to be in so that you don't jeopardize your child's benefits. And of course, we are here to advocate for you and to educate you. That's one of our biggest goals, is to help advocate for the public and educate them on what you should be doing for your loved ones in terms of planning for their future. Out of 263,000 financial advisors across the United States, fewer than 200 focus on special needs planning like we do. So you are truly in the right place when you're with Consolidated Planning Group and talking about financial planning, because fewer than 0.1% of all the financial advisors in the United States truly understand the nuances of planning for a special needs loved one. And we are those people. So a few quick bits of advice on the special needs planning side before I turn over the reins to our attorney, Ms. Donovan. First of all, think about what you want for your future and for your loved one's future, and start planning now. Doesn't matter how old or how young your child is, right now is the time to get started. Think about what's going to happen after high school. There are vocational options and residential options. There are educational programs at many different colleges across the United States built for students who need a little bit more patience and understanding and support. And tour those communities and those programs early to see how you feel. There could be waiting lists for the residential communities or for transition programs or day programs, any of that stuff. So check it out before you try to sign up, and then you find out that there might be a waiting list. And finally, the last bit of advice that we always want people to understand from our perspective, we work with a lot of adults who are now sibling caregivers, and they don't like it. They get really irritated when mom and dad leave no plan and no money, and they just say, okay, you're going to take care of your sibling. And the sibling who is being taken care of, the individual with a disability, they don't like it either. They're very resentful because now their partner in crime is suddenly trying to step into the role of more like a parent. So this resentment kind of goes both ways. So make careful consideration and plan very well before you just assume that a sibling is going to be able or willing to step into the role of caregiver. Again, I'm here. My email and phone number are in the chat box, as well as the link to our YouTube channel. And I would love to step aside and let Melissa take over, get started, because you're here to hear her, not me. So, Melissa, thank you for being here with us. I cannot wait to hear more about your thoughts on guardianship.
Thank you, Michelle. So my name is Melissa Donovan. I'm a certified elder law attorney. Here in Austin is where my office is located, but we do work with people all across the state of Texas. Unlike Michelle, I can only help people in Texas because that's where we're licensed. So if you are in another state, I would really encourage you to reach out to some local attorneys if this is stuff that you need to think about in your local area, because that is going to be highly specific and personal. That being said, I always have to start. This is the very lawyerly thing that we always have to do. This is meant to provide education. Nothing that I say today should be taken as personal legal advice because I don't know any of your personal situations. If you have questions that you need to talk to an attorney with, you should reach out to an attorney personally and have those conversations. Anything said today is just meant to be educational in nature. So that being said, I think, and having seen some of the questions that I saw come through prior, this is a big question that a lot of you have, because we think about guardianship and what is guardianship and why do I need guardianship or why don't I need guardianship? And then there's this, what is this thing that I'm now hearing about, this less restrictive alternatives? All of that is why we're here today. So we're going to talk about all of those things. We're going to give you a rundown on what guardianship, what that actually means, what that looks like, some different types of guardianship. And then we're also going to discuss what these less restrictive alternatives are. And essentially, less restrictive alternatives are what they sound like. They're just other options for people that maybe we don't necessarily need to have a guardianship over your child. And I will go back and kind of reiterate some of the things that Michelle was saying. When it comes to having this conversation, guardianship is honestly part of a larger conversation for all of my clients and for you as well, because it's one piece of a toolkit. You need to make sure that you've got good planning. You need to know that you've got some good education in terms of SSI and Medicaid. I saw some questions come through about, like what insurance and what options are my child going to have when they turn 18? There are a host of videos on the Consolidated Planning page, and I've done videos with them in the past. Other attorneys have done videos with them in the past. There is a whole lot of information out there about estate planning and special needs trusts and all of that. We're going to focus on guardianship today, but there's a host of information available to you if you just look for it. But when it comes to guardianship, there's two things that you want to think about. And we're going to spend most of today talking about the actual nuts and bolts of guardianship and when you need to get it. But you also need to think about, akin to what Michelle was saying, in terms of not necessarily counting on the fact that siblings are going to be there for their siblings. I will say there are some siblings that are more than willing to do that. And I have a very good friend who has been her sister's guardian for over 30 years now. And you couldn't pry it from her cold, dead hands if you tried to. That's not that common. So you really need to consider the family when you're making those situations and making those decisions, because if you end up needing to get guardianship over your soon to be adult child or your recently turned adult child, you do need to consider, as part of your general estate planning, who is going to take on that responsibility when eventually something happens to you. Because unfortunately, as they say, there are two things that are guaranteed in this life. And I don't really want to talk about taxes today, but we do need to consider that we're all going to die at some point. Okay. So we need to have those things in place. We need to think about those things and have those conversations. But let's kind of hone in on, why might we need a guardianship? Like, what is the issue here? And realistically, what it comes down to is that as a parent to an individual that has some form of an incapacity, a disability, when your child turns 18, the government doesn't care that they have that if they don't know that there's a situation. Your child at 18, as much as I might call everyone up until like 35 a kid, they're not kids. They're not children, they are adults. And when they become an adult, what that means is that all of the things that you have been able to help them with, take care of for them, you are not going to have the right to do that anymore. And while a lot of the people that you have long-going relationships with might work with you for a time being, you will run across eventually the doctor who's not going to tell you because they're legally not supposed to, the school that's going to withhold information from you. That's why we have these discussions, because as soon as your child turns 18, you don't have the right to make decisions for them any longer because they are a legal adult, but they might not be fully capable of making those decisions for themselves either. So that's where we have to weigh out, what is this potential guardianship going to look like versus maybe we do have some other alternatives that we can kind of go down that road. So the conversation that you really need to have, the purpose of this is to consider what you need to talk about. And you may start having these conversations with your spouse, with other family members, but eventually you need to have these conversations and you might need to sit down with an attorney and go through these things. But the first thing you always want to think about is, what is the actual concern? For my child, what is the condition that he or she has? Is that something that's going to last forever? Is it something that could improve? Is it something that really prevents that individual from being able to make any decisions, or can they handle some things on their own but not others? You want to think about what kind of things you still need to help them with. And maybe in, Sally's case, it's just minimal things that she needs help with, or we're just a little worried that she can kind of make decisions, but she might be easily manipulated or doesn't really know how to get all the information for herself, so she needs help making those decisions. But maybe Johnny does not have any ability to make decisions. Maybe the situation for Johnny is such that there's not enough capacity to really understand or handle anything. Maybe we need more assistance. So you really want to focus in on, what are the actual issues that my child has? What are the limitations that they have? And then from there, you can go to, well, what are the resources that we have? If I need to do 100% of this, it's going to break at some point. So you want to look at what those resources you have available, whether that is, the financial advisor who's helping you manage the money, or the doctors, or the school counselors, or the therapists, whether it's a local community, like if you have a child with Down syndrome and you're, part of Down Syndrome Association or something like that, what are those kind of community resources that you have that can help, whether that's educational, guidance, people to help you find, other assistants, therapists, et cetera. And then really making sure, because I tell people across the board, even when it comes to general estate planning, when there's no special needs concern, it really is a team effort. Like, nothing exists in a vacuum. So you want to kind of make sure that you're having these conversations and bringing in a group of people that are able to help you. So whether that's the attorney, the school counselor, who's going to help you look at what education programs are available, because there are situations where, maybe we're considering guardianship, but for school purposes, that could cause some limitations that we're not aware of. So, and we'll kind of touch on that a little bit later, a little bit more, but we want to consider all of these things. The biggest questions are realistically those last two, because that's kind of where the rubber meets the road when it comes to determining, do we really need to go a guardianship route? Capacity level of the individual, so of your child, let's say, and those limitations and abilities that they have. The reason those two are so important is the capacity question is going to be the primary factor for if guardianship is a necessity or even an option. Okay. And then the abilities and the limitations are going to help us determine what type of a guardianship we need and how full, what do we need to do within that guardianship. And that kind of gets into different types of guardianship that we have. Okay. So when it comes to guardianship in Texas, and again, keeping in mind this is focused on Texas, a lot of this is going to go across the board for other states. They might call things different. So there might be different terminology. For example, in California, they refer to guardians of the estate as a conservatorship. We call it a guardian of the state here in Texas. We have a guardian of the person, we have a guardian of the estate. And in many situations, you might have both. To be frank with you, if you are in a situation where you're looking at guardianship for a young adult child, most attorneys are going to try to get you outside of that guardian of the estate situation. The difference between those two is the way I like to explain it is a guardian of the person allows you to continue being mom or dad. I know it sounds really simple, but that's essentially what it is. Guardian of the person is the individual who has custody, care, and control of medical decisions, where the individual is going to live, making decisions about school, making decisions about healthcare. We might not be able to get married again. There are all these things that you're going to be the ones making decisions on. And later on in the presentation, if you forgive me, Michelle, will they have access to the slides after the fact?
Yes.
So
Yes, we're going to send the slides.
when you're looking through the slides, if you want to be able to kind of have that information handy, there's a list of things that you are actually taking away from. I really dislike the term, but we have to use it sometimes, the ward, your child, that you are retaining the rights on those things and you're saying they can't do these things. And you'll kind of see that here. But you can do a full or a partial guardianship. So you don't always have to say, we need to take away all of these things. In some situations, maybe we can still allow the individual to vote. I will be frank with you, I have never had a client where it makes sense to have the individual still be able to drive, but I could see a situation where that could happen. The most common one that I've run across in my practice is actually the voting, whether or not the individual wants to or will vote, but they don't want to have that right taken away from them. So this kind of gives you a list of what being a guardian would entail, but keep in mind, if we don't need to take away all of these rights, you don't have to. And then we also kind of talk about a permanent versus a temporary guardianship. And I always like to kind of explain that permanent is a little bit of a stronger statement than it actually is. Temporary guardianships are where we need to get guardianship in emergency situations. So those are things that they happen fast and they go away fast, hence the temporary. Permanent guardianship, truthfully, is not technically permanent. And the reason that I say that is once you obtain guardianship over someone, you do have to renew that guardianship at an annual basis. So every year you have to report back to the court and there has to be a determination made whether or not that guardianship is still necessary. So I have conversations with clients all the time because it can be very difficult to have to go through the conversation and think about the fact of, well, I have to bring my case to court. I'm telling a judge that my child can make none of these decisions, and then they're never going to be able to make these decisions for themselves ever. I don't know about any of you. I tend to be a glass half full kind of person. That's just how I generally like to look at things. And I like to have those conversations with clients because just because you need to get a guardianship right now doesn't mean in all situations that the guardianship has to last forever. If you've got a situation where it is quite possible that, from 18 to 25, your child could have enough improvement that maybe they don't need that guardianship any longer, when that time comes and you file that annual report with the court, you're going to tell the court that, and then they're going to dismiss the guardianship. So it's not really permanent, even though we call it a permanent guardianship. Now, going through kind of guardian of the person in a little bit more detail, and there's a process to getting guardianship, but when we're looking at guardian of the person and guardian of the estate, and as we go through these two slides, you'll kind of see why, as an attorney, we are always trying to veer away from a guardian of the estate. At a base level, guardian of the person is a lot easier on you as the guardian. Okay, there's not nearly as much court involvement over time, and it's not nearly as expensive for you over time. So it's just something that where we can, we try to avoid having a guardian of the estate. And in most situations, when we're dealing with a child who's turning 18, a young adult who maybe they turned 18, but you haven't kind of gone through the process yet, in most of those situations, we can get away without having to have a guardian of the estate. And they've made it a little bit easier in the last few years. But guardian of the person generally deals with the physical well-being of the individual. Like I said, you get to continue being mom or dad. That's the easiest way to think about it. With a guardian of the person, oh, can we go back to the,
Oh, sorry
sorry,
about that.
Michelle. So any guardian has to meet certain criteria. But when it comes to guardianship, there's typically, and I say that for a reason, typically going to be what we call a bond requirement. Now, if you're doing a guardian of the estate, 100% of the time, there's always going to be a requirement for a bond. There's no doubt about that. With a guardian of the person, most counties are going to require some kind of a bond. So most of my practice is in Travis County, Williamson County. I've done guardianships in surrounding counties as well. And I can tell you, it does vary. I started my practice practicing under Judge Herman, who is like the Texas guru for guardianship. All the judges kind of go by what he says for the most part. He's been doing this for a long, long time. Judge Herman, Travis County, you are going to need to get a $13,000 bond every time. Let me explain what bond mean, because sometimes that's a little intimidating for people. That does not mean that you need $13,000 to become a guardian. Okay. What that means is that you're buying an insurance product, essentially. That is a $13,000 bond. It can vary, just to give you kind of a general range, because I know these questions always come up. Typically, when you have to do these bonds, most people are doing what we call a lifetime bond now, which just means you buy it, you pay for it once, and it lasts for the lifetime of however long you're a guardian. The average cost of that is about $375 right now. I've seen prices range between $350 and about $400. That's for the bond. Now, not every county is going to require that. Here in Williamson County, oftentimes they just want $100 cash bonds. You might just have to put $100 down with the court. I've had guardianships in other counties where they didn't require any bond for a guardian of the person. So it does depend on where you are and the circumstances, and who it is that's applying for guardian. In those counties where they don't have a general requirement of a bond, they're going to look at all of the circumstances. And generally speaking, in my practice, what I've seen is that if you're the parent, they're generally not going to require the bond if they don't generally require it. Whereas maybe for an aunt or an uncle or some other person, they might, for a professional, they would certainly require that. But if you are guardian of the person, you do have a general right to make decisions for, as much as we have to use it on the paper, I'm just going to say your child, okay, for your child.
I think that sounds so much better anyway.
So I know your child is an adult, but we're going to continue to refer to them as the child. And if you're here for a sibling or a cousin or something like that, I apologize. I'm just going to use the term child for the sake of today. But with those rights do come responsibilities, as with most things in life. So when you are guardian, you have an obligation to provide care, supervision, protection for your child. So again, sounds a lot like being a parent, right? But you are the one who gets to make all the decisions. Now, what happens is that you do have to file one annual report with the court every year. Some counties require that that report is filed with the initial application, and then you're just filing an update of that same report annually. Some counties don't require an initial report, and you're just filing it on the renewal. But it's about 5 pages long, and it's essentially your ability to update the court on where your child's living, how the health has improved or deteriorated, what doctors, therapists, et cetera, they're seeing, kind of how things are going. But it's not that complicated. It's nothing that you necessarily, in the ongoing sense of it, and we'll get back to this on the beginning part of it, but it's not something that you necessarily need an attorney every year to do that renewal on. It's a relatively straightforward form that you would be able to fill out yourself. We're going to kind of go through what the beginning process looks like in just a moment. If we can slide to the next slide, we're going to talk a little bit about guardian of the estate here. And anytime we're talking about estate, we're talking about money. We're talking about assets. If you have an individual that you're trying to get guardianship over that does have what some people might not consider significant, but what the court is going to consider significant assets, you are going to need to obtain guardian of the estate. Now, in the past, you could have up to $2,000 in the child's name and not need a guardian of the estate. That could be handled by a guardian of the person. I said they've kind of made this a little bit easier. They've actually increased that up to $20,000 now. So there's a lot more people who may have had to get guardian of the estate in the past that don't need to do that any longer. If there are assets that you are managing as guardian of the person, there are some additional things that you'll have to do as guardian of the person, but you don't necessarily need to get guardianship of the estate. And that's a conversation that you would have with an attorney privately to determine what's best for your family. But if you have to get guardian of the estate, then you are going to have to file additional inventories and appraisals and things like that. So think like if you had to guardianship for an aging parent type of a situation. And, if I've got a parent that's come down with dementia and I need to get guardianship over them and they've got a house, they've got retirement accounts, and let's say they never did proper estate planning. So now I have to go get guardianship to be able to help them with those things. I have an obligation to tell the court, this is everything that person has going into that. And then ongoingly, I have to let them know how the investments are doing, how that money is being managed, what it's being used for. And in some situations, you have to get permission from the court to do a lot of things. So a big example is, let's say we've got a house that we're dealing with and the house needs to be sold. I can't sell that house as guardian of the estate without getting approval from the court to sell it, approval from the court on who the realtor is and the fees that they're charging, approval from the court on the listing price on it, approval from the court on the sales price once we get an offer. So there's a lot more involvement when it comes to being a guardian of the estate. So as you can kind of see, if we don't need it, we don't want to put anyone through that. But there's just a lot more. And when you have a guardian of the estate, you always need to have a bond that's posted, and it's dependent on the judge what that's going to look like, but it's going to be significantly more than a $13,000 bond. And I'm going to interject for a second because I do see that someone had asked, what is the purpose of the bond? The purpose of the bond is to protect two things. Idealistically, it is to protect the child. Okay. Practically speaking, it is also to protect the court. Because when you have guardianship over someone else, it doesn't matter if it's your child, your parent, whomever, you are essentially acting as an agent of the court. You are the guardian, but the court is responsible for you. So if you as the guardian make a mistake, something happens, the purpose of that bond is to provide some financial protection for the ward, and as cynical as it might sound, connected to that for the court, because the court has ultimate responsibility for what you do.
Well,
That's why judges require that.
It makes sure that you have a little skin in the game, right?
Right. Yeah. Now, the whole question that most people have is, what does this process look like? How long does it take? What all is involved? If I'm going to focus in on getting guardian of the person, guardian of the estate is going to be similar, albeit a few more things that we'll have to do in terms of inventories and things like that. But the first thing I will tell you is that typically timing wise, it is best to start this process, meaning start talking to attorneys, start figuring out who you want to work with at least 6 months prior to your child's 18th birthday. If you didn't do it prior to your child turning 18, that doesn't mean you can't do it now. But you just want to be prepared that it can take a while. Even with what we call an uncontested guardianship, which a lot of in these cases, they're going to be what we refer to as uncontested, meaning we don't have like mom and dad fighting over who's going to be guardian. You don't have someone coming in and trying to step in that is fighting with you. It's mom and dad want to be the guardian together, or, one of you wants to be the guardian, the other is in agreement when it comes to divorced couples. If nobody's fighting about it, we have an uncontested situation. My longest guardianship in an uncontested situation still took 8 months. Okay, so you just want to be prepared that this is not something that you start the process on 2 weeks prior to your child turning 18. It will take some time. And a lot of that has to do with who is appointed for people and how long, the dockets are backed up in the court that you're in. There's a lot of variables that go into that. But the process typically starts with one of two things. And it always comes down to essentially a medical determination, we'll say. So There's two ways that you can go about doing that. You can either do a physician certification or you can have an intellectual disability report. The time frame on those two things are different, because if you have a child with an intellectual disability and they've had a report done, that report can be used for a period of 24 months after it's done. So if, let's say, your child turns 18 this summer and you had one of those reports done not last summer, like summer of 23, let's say you had it done, you might still be fine, so long as you can get a hearing within 24 months of the date that that report was done. You might not need to do anything else. If you don't have that, then you're looking at a physician certificate, which typically is done by, in many cases, the pediatrician, or if, let's say, you have specialists, like you've got a neurologist or something like that that your child works with, you can have it done by any of those doctors. That needs to be signed by the doctor within 120 days of the filing, meaning when you apply to the court. So you don't have quite as long on those. But if, let's say, we don't have an intellectual disability report that we've had done in the past, and we're just kind of starting out, 6 months is a good time frame, because what's going to happen is you're going to have your doctor or your child's doctor fill out that form, fill out that physician certificate, and then you have to get that back. I know it's not everyone's favorite thing to hear, but you do have to have an attorney if you are applying for guardianship. The reason for that is that non-attorneys cannot represent themselves when they're trying to represent other people. The court looks at that as unauthorized practice of law. So you do need an attorney for the application process. And that's just something that you'll need to, sit down with some local people and determine who makes the most sense for you. But if you have that letter and you've got that certificate and you go to meet with the attorney and you hire that attorney, what's going to happen is the attorney is going to prepare your application. Okay, so we have to prepare an application for the court. It has to be signed by you, it's signed by us, and that application is submitted to the court. The court is then going to appoint what's called an attorney ad litem for your child. The reason for that is that when you hire an attorney to help you with the application, that attorney represents you. They don't represent your child. And by filing the application, you're saying my child doesn't have the ability to hire their own attorney because my child doesn't have capacity to do so. Hence why the court is always going to go ahead and appoint an attorney ad litem. That attorney ad litem, where they come from, because that's always a concern for my clients. I know when I'm sitting down with them, they always have questions, who is this person and what kind of an attorney are they? It kind of does depend on where you are in the area, but those ad litems come off of a list. So the court has essentially like a roster of attorneys who apply. I don't want to say volunteer because they are paid, but who enter the list, and it's kind of like a rotating list of people. If their name comes to the top of the list, the next time there's a guardianship, they're the ones appointed, barring there being very special circumstances where maybe they need to appoint someone of specialty or something like that, but that's relatively rare. Most of the attorneys on this list are attorneys like myself. So they're estate planning attorneys, they're special needs attorneys, maybe they're family law attorneys. A lot of them are family law attorneys. So they might do divorce work, they might do guardianship and several other things. Very rarely, but I have had it come up where the attorneys on the list are criminal defense attorneys, which there's nothing against criminal defense attorneys. But the reason I say that is I always tell my clients, who you get as an ad litem has a big effect on how long things take and how pleasant the experience is. And certain attorneys have different attitudes about things, and that doesn't make one of them better or worse than the other. It just affects the overall kind of feeling in how things go, because different attorneys are always going to take things from a different perspective. And some people are, if you're a litigator by practice, you're going to have that in you to litigate a little bit more. Whereas special needs attorneys, people who focus more on guardianship in this context or estate planning, people generally go into estate planning and special needs because we're not litigators. So the interactions are going to be a little different. That being said, these are attorneys who have to be guardianship certified, so they are vetted. They have education, they have expertise in what it means to have to deal with guardianship. So that doesn't mean that they don't know what they're doing. They do. It's just that different people have different, just like in anything, different people take different perspectives and they do things differently. But when it comes to that 8-month guardianship here that I had, that was with an attorney who was a criminal defense attorney. My quickest guardianship took about 2 months. That was with an estate planning attorney, much like myself. So it's just differences. Again, one's not good, one's not bad, one's not right, one not wrong. But just to you want to go into things. I'm a big proponent of going into things with eyes wide open and having good solid expectations of what to happen, what could happen, so that you don't get into a situation where you think this is going to be super quick and then it goes a different way. You want to kind of know what's going to happen and what could happen. But once that ad litem is appointed, their job is to represent your child. So they're going to meet with you, they're going to talk to your child, they're going to file a report with the court. And then once that happens, then we can set a hearing. Now, if your child hasn't yet turned 18, you can't actually have the hearing until they're 18 years old. And in most courts, they won't let you have that hearing until at least a week after the 18th birthday. So 9 times out of 10, you're not going to have guardianship the day that your child turns 18, and that is okay. Going back to something I said earlier, if you've been working with schools, doctors, people that are used to working with you, I have literally never had a client come back to me and say, I can't get anything and this doctor refuses to talk to me because my child turned 18 yesterday. If they know that you're working through it and these are people that are used to working with you, it is highly unlikely that they're just going to say, nope, sorry, your child turned 18, too bad. They usually will work with you, especially if they know that you're going through the process of getting guardianship. Now, there are some additional things that have to be done within that time frame. You do have to take some coursework. It's online. It's with what we call JBCC here in Texas. So you have to get certified. Even as a parent, they require it of everyone now, but it's a pretty straightforward. It's about an hour-long webinar that you take, but it's a requirement under the court. Once all of that is done and you have your hearing, then the judge is going to basically say yes or no. And if it's uncontested and it's pretty clear, the judge is going to grant the guardianship. And then you're going to get what we call letters. Okay. Letters, whenever you hear that term, are your permission slip. Okay. So like if I've got my estate plan and I've got my statutory, my durable power of attorney, that's, my husband or my sister's permission slip that if I can't write my checks, they can do it for me. Your letters of guardianship are your permission slip that you're going to give to the doctors, to the school, etc., telling them that you are the one who has the right to make those decisions and get that information. So once you have your letters, then you're good. Then you are the guardian and you're going to take action and you're going to continue being mom or dad. Or if you're not mom and dad and you're, a sibling or whatnot, you step into the shoes of what would have been mom or dad in that situation. Now, who can act as guardian? There is a hierarchy, just like with most things when it comes to these. So in the statute, there's a hierarchy of essentially what is next of kin. So if someone is married, that would be your spouse first and foremost, then your parents, and then we would go out to other family members. So adult siblings, grandparents, aunts, uncles, etc. We have a habit of saying that you cannot be a guardian if you are a felon. That's not actually true. One, the statute has never said that. It has always said notoriously bad conduct, which is a little wide open. Could mean a lot of things, but it does leave room for interpretation. Now, in terms of these are kind of rare. It's pretty rare that someone's going to try to get guardianship who is a party to a lawsuit against that person. But a minor, of course, can't be a guardian. An incapacitated person, of course, cannot be a guardian. But most situations, it's going to be siblings, parents, maybe grandparents, just kind of depends on who's around the individual. Now, I'm going to take a step aside because I know we've got a couple of questions here. I'm going to kind of jump. There was one I saw, if I talk to an attorney, can I do it pro se? No. Again, it goes back to the fact that a non-lawyer cannot represent yourself in trying to represent another person. I know that's a lot and it seems kind of superfluous, but it's the way that the law works in Texas. Now, are there organizations that can help if you are lower income, you can't afford to hire a private attorney? Yes. And I would always recommend that if you're in that situation, first and foremost, I find that the best place first to start are your local kind of what I would call specialized support groups. So for example, like CPATH or Down Syndrome Association or places like that.
The ARC of Texas.
ARC of Texas is a good one. And then beyond that, you can always contact your local referral services. Most local bars have legal referral services, and they can kind of connect you if you don't have other community organizations that offer those services. ARC is a great place to go first. Other than, like I said, local groups are really helpful. And there's a lot of reasons. If you are not already involved in local organizations, that local support groups, there are so many reasons to get involved with that outside of, like, yeah, they can give you referrals for good professionals. They're just helpful. You know, most of my clients, the information that has been most helpful to them outside of, you know, sitting down with us has come from a conversation that they've had at, you know, a CPATH meeting or a Down Syndrome Association meeting. Though you are sitting down with people who have been through what you are going through. And those are always going to be, in my personal opinion, take it for what it's worth. That's always going to be the most valuable advice that you can get. Because if you have someone who's been through what you've been through and they've had to go through it, they're going to tell you, oh, I worked with that person and I didn't like them. Or I worked with that person and they were awesome and they gave me all these other things. Or I went to that group and they really were great. And, you know, they were able to help me and they didn't charge because it was pro se. So go to those places, go to those support groups. Don't be afraid to reach out. Even Facebook groups, you know, everybody's got a moms of this or moms of that Facebook group these days. I can't tell you how many of my friends and clients have just garnered really, really great advice. And again, you take everything with a grain of salt, but when it comes to things like that, reach out to everything that you can. Okay. When it comes to specific organizations in specific areas, unfortunately, I'm not going to be able to give you everybody answers for that. But I would, if you're really uncertain, then the best thing that you can do, other than just Googling local support groups, is you can contact your local lawyer referral services, and they can usually guide you at least in the right way for an attorney that you could talk to. Now, continuing on.
Well, there is one question about who can act as guardian, since we're still on this slide of the notoriously bad conduct. If biological dad has a felon record, but the wife is clean of any criminal background, can she file for guardianship?
So unfortunately, lawyers make things more complicated than you think they are. Is wife is it depends on if wife is also mom. Okay. If wife is stepmom, she would not have the right over biological mom. But if wife is mom, legal mom, then yeah, she can file for guardianship.
And what about citizenship? How does that play into?
So citizenship, if they are your child, that's one thing. Okay. If, let's say, you are a non-citizen, because this is where this question tends to come up, is this comes up a lot for me with my estate planning clients, not necessarily my clients with special needs children who are in this situation that we're talking about right now, where, like, we have a lot of, in my practice, we have a lot of clients whose family are in India. It's just a very common experience that we have here in Austin. And what happens is that a lot of the times, you know, mom or dad or sister or brother, they're in India. And the question does come up, you know, like, can I name my brother in India as my guardian for my child? The answer to the question is you can, but it's going to be very complex and very time consuming. And there's going to be a lot of hurdles that that person's going to have to jump through. And a lot of that is jurisdictional. Okay. Now, if you have a resident, like your sibling is a non-citizen, but they're a resident of Texas, that's a different story. Okay. So it's just, again, I know people hate it when lawyers make things more complicated than you feel like they need to be, but there's just a lot of aspects and variables that go into that. Is it a non-resident non-citizen? Is it a resident non-citizen? Where are they located? But the one thing to keep in mind is that what the court is always looking at first and foremost is what is in the best interest of the child. Okay. So anything having to do with guardianship, anything having to do with family law in general, when there are children involved or incapacitated individuals involved, everything has to be done within that framework of the court saying, what is in this individual's best interest? And a court could decide, let's say we've got a, you know, 19-year-old who's receiving all of these services and they're on benefits and they live here in Texas. And now we've got someone that wants to be guardian, but they live, I mean, it might not even be out of country. It might be that they live in Massachusetts. And a judge could say, is it really in this child's best interest to have to uproot to another state when all of their supports and services are here? So there's a lot that goes into it. It's not a strict black and white, like you're a citizen, you're not a citizen, that's a yes, that's or no. So at risk of taking the entire rest of the afternoon to go through all of the permutations of that, I'm going to leave that there.
Thank you.
But in terms of why might we want to look at other options? Okay, I mentioned earlier, and I had this come up. I've had it come up in the past, but I want to talk about it because it's something that I've had come up recently with a client of mine, where when you have the conversation, you're really considering, and it sounds like guardianship is going to be the route that you have to take. But then what you find out is that, because every situation is different, but there are situations that are very clear, where it's very black and white. This person is never going to be able to provide for themselves. They're not going to be able to live independently, and we need to get a guardianship. And there's no issues with that. And then there are people that don't need anything. I get that too. I get clients who call and they're very concerned because it's like the WebMD thing. Like we all have a habit of, we get down this Google nightmare road where we're just looking and looking and looking. And like, by the time we're done, we're like, everything is the worst case scenario. And everybody tells me I need guardianship. And then you get on the phone with someone who can talk you through it. And we go, no, you don't. If your child has, and it doesn't have to be that they are able to make every single decision for themselves, but if your child does have the ability, even if with a lot of explaining, but they have the ability to understand, like, I can sign a document, I can sign a power of attorney that gives mom or dad or my sibling or whomever the ability to help me, and they can have access to my bank account and write checks for me, or they can talk to my doctor because I'm signing this HIPAA authorization and I understand that that gives them the right to get information. If your child is in a category where they have that ability, then we're looking at, okay, what are those alternatives? Because realistically, we don't want to get guardianship when we don't have to get guardianship. And where it can kind of become complicated is when we have those situations that it's kind of on the fence and sometimes you're leaning at initial conversation to say, sounds like we probably do need guardianship. And then when you're looking at college courses and you're looking at college paths for your child, and you run across a situation where they won't accept children who are under a guardianship. So these are the things that you really want to take into consideration, and a good attorney that's walking you through these things are going to discuss these things with you, because you might be at first glance thinking, I need that guardianship, but then when you talk through the whole thing, is the guardianship worth losing that opportunity? Because most people that I talk to, when you've got children that are in that middle ground, that's first, middle ground on everything is always the hardest. Okay. That's always the hardest because you have options. It's like anything else. Like when you go to Cheesecake Factory and you've got a 75-page menu, it's harder to decide what you want to order. When your child's in that middle road where, okay, we could do guardianship, but we could also do powers of attorney, and we could do this thing called a supported decision-making agreement, and that would help for a little period of time. But then we've got these other things like, I want my kid to go to school and I want them to have these opportunities to grow, because ultimately I want them to be able to be independent and provide for themselves. And if we do guardianship, we're going to be blocking that opportunity. So when we think through all of those things, if we have a situation where your child, like I said, even if it requires a lot of conversation, even if it takes the attorney more time to explain things, but if your attorney sitting down with your child, and keep in mind, if you're working with an attorney and then you go this route, the attorney represents your child at that point, because it's no different than you going to an attorney to do your own wills and your own powers of attorney. That attorney is talking to your child, okay? And it's their job to explain to them what is a power of attorney and make sure that they understand it. Now, do they have to understand it at the level that a law student? No. Do they have to understand it at the level that any other, adult? Everybody understands things differently. So don't feel like it's a situation where everybody has to have this like expertise understanding of things. They have to understand that I am signing this document that's giving this person some authority to help me and do things. The difference with the supported decision-making agreement, and this is something that in the grand scheme of things, it is still relatively new. And sometimes that seems weird because in an age where there's a new iPhone coming out every 6 months, it feels like new in the eyes of the law is pretty much anything that's happened in the last like 20 years because the law doesn't change that much. In some situations it does, but the law doesn't change a whole lot. So when things are kind of 10, 20 years old, it might seem like they've been around forever, but in the grand scheme of things, they're relatively new. So supported decision-making agreements, those came out, we're about 10 years in at this point. Texas was actually one of the first states to authorize supported decision-making agreements. And I am always very upfront with people. When I first started doing this and first started looking at supported decision-making agreements, I was kind of one of the naysayers, okay? Like I was kind of in that camp of this doesn't really make any sense. And if this person has the ability to sign this document, why are we not doing these other things? And if we're kind of saying they do have capacity, but they don't, I have switched a lot in the last 12 years, okay? I find myself doing these with clients a lot more often. The point of a supported decision-making agreement, if we can continue on to the next slides, the point of a supported decision-making agreement is it is giving you the power to help your child make decisions, okay? And I know that probably sounds strange, and it probably sounds like, well, I don't understand it fully, and what's the purpose of this? The idea here, guardianship, you make the decisions. You are in charge. Your child has no right to self-determination, essentially, okay? With a supported decision-making agreement, what is being agreed? It's a contract, okay? But the good thing is that the level of capacity required for the signing of this is it's almost the lowest level of capacity that's necessary. The only thing that is slightly higher than is actually what a lot of people find odd is signing a will is one of the lowest required capacity levels. But when it comes to this, they just have to be able to understand, I am signing this contract, which is allowing whoever it is, I always say parent, child, but whoever it is, it's allowing you the ability to garner information. These always need to be accompanied by a HIPAA authorization. Okay. And what they're also typically accompanied by is there is an educational release that needs to be signed as well. So you have a supported decision-making agreement, a HIPAA authorization, and that educational release. Now, if your child has nothing educationally going on at that point, you don't necessarily have to do that. But the point of this supported decision-making agreement is it gives you the ability to get all of the information from doctors, schools, employers, anything that your child has to make decisions on. You have the right to be present. You have the right to help them understand what is being told to them and kind of pull in that information. But your child is still the one that makes the ultimate decision. So you can give them all of the advice. You can walk them through all of the decisions. But by signing those agreements, you're saying, I don't need to be the one to make the decision. I just need to be there to help my child be able to make a good decision. Okay. And that's the way you want to think about it. And those can be extremely helpful now, much so more than they were 10 years ago. And a lot of that just has to do with, like most things, people aren't used to seeing them. It takes 5, 10, 15 years for businesses, hospitals, et cetera, to get used to dealing with new things. So we've kind of reached a point that, at least in my experience with clients, they work a little bit better now than they did right off the bat. People are more accustomed to them, and they can be done. Now, supported decision-making agreements, yes, I am biased. I am always going to recommend that it is best practice to sit down and go through these things with an attorney, but they don't need to be done with an attorney. But it's just something to think about. Okay. And it could be very, very helpful in your situation. And if you are in that situation where you have been looking at college provisions, you might need to second guess guardianship. Okay. Because something to be aware of. Forgive me, I just thought there were a couple of other questions. Like I said, supported decision-making agreements, they're going to be accompanied. Typically, personally, when I do these with clients, these always accompany kind of what I would call a mini estate plan. So medical powers of attorney, financial powers of attorney. It's a good idea to get all of that stuff done. That doesn't mean that that's what everybody does. If we can continue on. Again, this just provides a little bit more written information. If you get the slide, if you want to keep the slides later. So when it comes to full, partial, all of these less restrictive, kind of pulling everything together, as you can probably tell, it is a very personal decision. Whether you need to do guardianship, a supported decision-making agreement, guardian of the estate, guardian of the person, a full, a partial, but you need to make sure that you're going into those things eyes wide open, having thorough conversations with your team, your child's counselors, therapists, doctors, your family, your financial advisors and attorneys and all of that. It all kind of works together. And once you're able to have all those conversations and pull all of the pieces together, then you can truly make a better decision for you and your family as to what makes the most sense. Okay. I do include a little bit of information here. I'm not going to spend much time because I know we're running close on time here. A little bit talking about elderly parents. So much, I know probably the vast majority of you in this room, if not all of you, are here because of adult children as opposed to parents. So I'm not going to spend too much time, but there are options and information if you're dealing with parents, because some of you might be dealing with both. If you're around my age, as much as I still like to think of myself as being 25, we're not, and we're in that sandwich generation. So you might be in a situation where you are not far off from taking care of your kids and having to look at taking care of your parents too. So it's just good information to have all around. I do want to address some of the things that I do see. If you don't mind me, I'm just going to I can see some of them here, Michelle.
Absolutely, go ahead. I'll leave your contact up, and then in a couple minutes, I'll put my contact up and how people can contact us for a free consultation with Consolidated Planning Group. But you keep going. I'll just switch the slides in a little bit behind the scenes.
So the couple of things that I saw come through. So Erica had made a comment about the cost of guardianship. To be frank, that $5,000 to $6,000 range, it is going to depend on where you are, but that is a common price range in the Austin area. I would venture to say that probably, Dallas, Houston, you're going to be looking similar. If you're in smaller counties, more rural areas, it's probably going to be a little bit less. And a lot of that is because of attorney's fees and court costs as well. Different courts have different fees. So it's something that you need to look at your local area and talk to your local professionals to make the best decision for you. But on average, yeah, a guardianship, if you're looking at hiring an attorney, not a, nonprofit organization or something like that, but like a private attorney, you are probably going to be looking close to $5,000 to $6,000 for that. There was also a question here about switching. So I have a guardianship, or I started the guardianship process, and can I switch to decision-making agreements? The short answer to that question is maybe. Again, it depends on your child's level of capacity and what they do and do not understand. But going back to what I said earlier, if you already have guardianship and you have a permanent guardian, that's not permanent. You have to renew it every year. So if the situation improves and you don't need that guardianship anymore because there are other options that are viable, then maybe you don't always need to keep that guardianship in place. The other thing here, why are students with guardians not accepted to colleges or universities? I will be frank with you. I don't have the black and white answer to that question. But a lot of it does go to autonomy of the child. And maybe the cynic in me, it's probably a lot for the protection of the school as well. But I would ask that question to the schools because they're going to be able to give you those answers. That's not something that I can really give you the straight answer on. We can all pontificate about the reasons for things, but it's usually better not to do that. And then how long does it take to make a supported decision-making agreement? That all depends on how you're doing it. If you're going to an attorney, it just depends on when you can meet with the attorney and whatnot, and how long that attorney takes to have those conversations. Again, just like with any area, any specialist, different professionals are going to work differently with people. So you might have one attorney that really likes to dig deep and get to know their clients and have long conversations to really make sure that it's the right thing that they're doing. And then you might have another attorney, not that they're doing anything wrong, but they just work more quickly. They don't deep dive quite as much. And that's just a matter of practice and different people doing things different ways. So, could you have a supported decision-making agreement done in a day? Sure. It just kind of depends on who you're working with and how you're doing it.
Well, thank you so much, Melissa. Do you see anything else that you want to tackle? I mean, we're kind of out of time, but I appreciate you so much for being here. Melissa has put her contact info in the chat box, and of course, you can schedule with me. You can call Melissa or email her directly. What's better for you, Melissa?
So I've gone ahead and put my contact information for our firm in the chat box.
Okay.
So you are welcome. If you have a question, need to schedule a consultation or anything like that, you can email or call that number or email address. But I mean, thank you all for coming. I'm really glad that y'all are here. You're learning, you're participating in your support groups, as I said. So that's the
Yeah.
first step. And
It is so important. I really appreciate you, Melissa, for being here and going through all of this fantastic information. And for everybody who's hung out with us for the past hour, we definitely appreciate you being here. Please feel free to contact either Melissa or myself if you have questions, if you want to schedule a consultation, any way that we can help support you, we're here. Thank you all again. Have a great week, and I hope to hear from you soon.
have a great
Thanks a
one.
lot.